Hello and welcome to this short piece on conducting civil litigation in England and Wales, specifically the overriding objective of the civil procedure rules. My name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers. So what is the overriding objective of the court's rules? The procedure rules, or CPR as they're known, have the overriding objective of enabling the court to deal with cases justly and at a proportionate cost. Now, both of those aspects are very important. They constitute the overriding objective, but proportionate cost has recently been added and is now a vital aspect of this concept of the overriding objective. So you always need to think about the way in which the case can be managed at a proportionate cost. So you don't take the proverbial sledgehammer to crack a nut. The costs, in other words, must have a reasonable relationship to the following things: the sums of money in the case, the value of any non-monetary relief, such as an injunction or declaration, the complexity of the litigation, any additional work that's generated by the conduct of the parties, wider factors such as whether reputation or the case being of public importance is involved. And the upshot of all this is that costs can be disproportionate even if they were necessarily incurred, and the judge can look at the overall costs involved in the case and say, well, these are simply disproportionate, and similarly can look at the overall costs of taking any step and say it is not proportionate to take this step because it would involve disproportionate cost. The court has to give effect to the overriding objective when it exercises any power that's given it by the CPR. So what's meant by dealing with cases justly and at a proportionate cost? The rule that defines this states that it includes, so far as is practicable, ensuring that the parties are on an equal footing. I'm going to say a little bit more about that in a moment. Saving expense, dealing with cases which are proportionate to the amount of money involved, to the importance of the case, to the complexity of the issues, and to the financial position of each party. It involves, so far as is practicable, ensuring that the case is dealt with expeditiously, quickly, and fairly. One other aspect of dealing with cases justly and at a proportionate cost includes allocating or allotting to the case an appropriate share of the court's resources, while taking into account the need to allocate or allot resources to other cases. So in other words, your case is not going to be the only case that is relevant to the consideration of whether it is just to deal with your case in a particular way or in another way. Finally, a new aspect of the rules, which is vitally important, is that the overriding objective now includes a requirement on the court to enforce compliance with rules, practice directions, and the orders that it makes. So in other words, dealing with a case justly and at proportionate cost includes, so far as is practicable, enforcing compliance with the civil procedure rules. One aspect which I wanted to develop slightly is this concept of equal footing. And what it means is basically what it says. You should be on the same procedural level as your opponent, and you shouldn't be put at a disadvantage procedurally in putting your case to the court by the fact that you're representing yourself. Being on an equal footing may mean that those who've got more resources may be expected to do more than those with fewer resources in the course of a case. However, many litigants, especially litigants in person, think that this idea that they're to be put on an equal footing with, say, a professionally represented other party means that they can avoid doing things which the rules require them to do. Now, this has never been the case, and under the latest statement of the procedure rules, it most certainly isn't the case, because one of the aspects of the overriding objective is, of course, to enforce compliance with the rules. So don't use this idea of being put on an equal footing as your opponent as an excuse not to do something. You can, however, deploy it as an argument that it's not fair to expect you to take a particular procedural step because you don't have the resources, for example, to do it, or it's better that the other side should undertake a particular step because they do have the resources to do it, or they can do whatever it is that needs to be done to a greater extent than you, or more quickly, etc., because that would put you on an equal footing with them. But you should deploy it as part of an argument before the court orders you to do whatever it is, and not use it as an excuse for having not done whatever it was that the court ordered you to do, or whatever the rules required you to do. You can expect, therefore, not to be put at a procedural disadvantage by the fact that you're litigating for yourself, but it isn't a trump card which you can play if you've failed to do what the rules require you to. I want finally to talk about one new enforcement aspect in the procedure rules, which is this idea of the overriding objective including enforcing compliance with the rules and practice directions and orders. The rules have always included a rule relating to what they call relief from sanctions. So if the rule says that something happens to you if you don't do what the rule has said you must do, then you can apply for relief from that sanction being imposed on you. However, the new rule states that on an application for relief from any sanction imposed for failure to comply with the rule, practice, direction or court order, the court will consider all the circumstances of the case so as to enable it to deal justly with that application, including the need for litigation to be conducted efficiently and at proportionate cost, and secondly, to enforce compliance with rules, practice, directions and orders. So in other words, it's going to be difficult to obtain relief. You should therefore ensure that you always read correspondence from the court very carefully, and in particular read the court's orders. Where you see a time limit for doing something, then pay attention to it. Now that time limit might be in the rules themselves, or it might be in a court order, or it might be in a practice direction. Once you've spotted the time limit, put it in a diary. I'd suggest that you knock some time off the time limit to remind yourself to do it before the time limit expires. Do it in good time before the time expires. And in general terms, it's better to do things earlier in the litigation rather than waiting until you're right up against a time limit.